What an unbelievable time to lose my glasses. Nevertheless, it's my pleasure to introduce this current panel on the International Criminal Court. Many of the panelists are longtime colleagues and friends of mine. Paul Heinbecker is not, and I'm looking particularly forward to hearing his remarks, which I understand will be if I'm not mistaken, those will be about the ICC, but also placed in the broader context, which I think will be an excellent way to start off the panel. We also have with us David Scheffer, who is currently visiting professor at Georgetown University, and has, as you all know, been really at the forefront of this field and really guiding U.S. policy, which in turn has certainly influenced major international developments in this area. After serving as senior counsel to Madeline when she was a permanent U.S. rep to the UN, he became ambassador at large for war crimes issues. And in each of those capacities negotiated at first the statutes and structure of the International Criminal Tribunals for former Yugoslavia and Rwanda, and then of course was negotiated for the U.S. ICC delegation in Rome. Diane Orentlicher, also a colleague of longstanding at the American University College of Law, has really been outstanding in this field, I would say particularly since, and long since, her article in the Yale Law Journal on the obligation to prosecute, an issue that has continued to be terribly important in this field, particularly now posed in terms of amnesties, and whether amnesties are permissible after situations of atrocity, after genocide, war crimes, and crimes against humanity. So her work at that time and since on all issues of international criminal law has been central in the field. Alfred Rubin, currently emeritus professor of law, emeritus professor at Tufts University, but not of law, has also, and I say of law probably as a sort of Freudian slip, because among the international criminal lawyers in this sort of usual set of suspects, his role has for a very long time been central and important in some sense, and in some large part of his work, focusing on the issue of piracy, which is sort of perhaps the original international crime, but also through that really in-depth and intricate research that he has produced on that subject, really, I think, led a lot of our thinking, certainly mine, on the subject of universal jurisdiction, as that has developed historically, and particularly within the last decade or so, and allowing us to reach back to the origins of universal jurisdiction, and in that way be able to trace forward that new and important form of jurisdiction. So without further ado, and I won't be jumping up and down this way, having introduced everyone, look forward to our panel. Thanks so much.
I've been asked to speak about the Article 16 and the Article 98 debates of the International Criminal Court, and I'll do that. Particularly how they impinge on Canada-U.S. relations and U.S. relations with the rest of the world. But I'm going to do it pretty briefly. You'll have to take my word for it that I have an answer to every accusation that might be raised against our position. But for those who are not lawyers and who are not following the International Criminal Court, Article 16 and Article 98 of the Rome Statute and the International Court of Justice are the articles under which the U.S. has been trying to shield its military personnel and indeed non-military personnel. And in fact, a whole lot of other people, contractors, even mercenaries, would be covered by the U.S. Article 98 agreement. set a little bit of a context, and that is what the Canadian government's position was. The Canadian government position, fundamentally, was that the creation of the International Criminal Court was a good thing, was a major step forward in the development of international law and in the development of international relations. Ending impunity for the world's monsters. I'm not talking, this treaty is not aimed at U.S. GIs. Ending impunity for the world's monsters, ending immunity from prosecution for the worst crimes, is both manifestly positive in itself and important as a deterrent of future crimes. And that's no small consideration at a time when we're worrying about international stability and its relationship with terrorism. We opposed the U.S. government's attempts to exempt Americans, in this particular case it was peacekeepers, from the court's jurisdiction, American and anybody else. We thought the U.S. objection, we understood that there was in this country a strong sentiment that because the United States had a major responsibility in the world, it would be subject to a political attack. We understood that, but we thought the treaty provided plenty of protections against that, and we saw American objections as essentially ideological. It was a kind of American exceptionalism taken to an extreme. American exceptionalism is not new, of course. I hesitate to even discuss it in front of Americans who know it inside and out. But it's been around since at least the Declaration of Independence. De Tocqueville commented on it. Margaret Macmillan in her book 1919 discusses it. Michael Nashif has been discussing it in the New York Times, and Harold Coe of Yale has written a very long piece. I think it's a Stanford Law Review, a very long piece on it, and a very good one. The problem is not the problem of exceptionalism. The positive elements of American exceptionalism, the extraordinary activism and power that the United States has brought to bear on the development of international law and the promotion of human rights and the protection of human rights. That sort of exceptionalism is the kind that we all like to see. The problem arises when it becomes a case of double standards. And that, I'm basically, in a second, I'll quote Harold Coe. One law for the goose and one for the gander. And this is a quote from Harold Coe. When the United States actually uses its exceptional power and wealth to promote a double standard. In those cases, exceptionalism isn't benign. It's a kind of ideological problem. And exceptionalism became exemptionalism in the course of this discussion. We disagreed with the U.S. position because we thought it meant that all people would not be regarded as equal and accountable before the law, and that was a principle that we didn't want to see deviated from international law. We thought Resolution 1422 was unnecessary and ultra-virus. Ultra-virus because the UN Security Council was doing two things which we thought were not acceptable. It was purporting to act, I'm going to use the word purporting a lot, I hope that doesn't trouble people, we're probably claiming this in maybe a better English. It was purporting to act under Chapter 7 of the UN Charter. Under the UN Charter, Chapter 7 action is possible when there's a threat to international peace and security that's identified. Acting under Chapter 7 on this particular issue, which was the extension, the rollover for a very short period of time of a Bosnian peace mission, meant that either peacekeeping was a threat to international peace and security, or the International Criminal Court was a threat to international peace and security, or U.S. policy was a threat to international peace and security. But there was no actual fact, there's no threat to international peace and security was actually identified. And so the Security Council was exceeding its mandate in acting under Chapter 7. We also thought that the resolution diminished the importance of accountability and justice for the victims. that it undermined fundamental principles of international law, and that in seeking to impose its interpretation of Article 16 of the Rome Statute, the UN Security Council was actually arrogating unto itself the right to impose interpretations of existing treaties, whatever the states parties to those treaties might have thought. And initially, there was widespread opposition in the Council to this approach. The first approach was to give peacekeepers for those countries, particularly who hadn't signed the ICC, exemption in perpetuity from the jurisdiction of the ICC. I personally wrote to the President of the Security Council not once but twice. The President of the Security Council at the time was British. He brushed us off. We wrote back again a public letter that went to everybody in Rubin, every single delegation, saying that on an issue of peace and security, the DOM peacekeeping missions, the future of an international court dealing with war crimes, crimes against humanity, and genocide. But this was not the kind of issue the Security Council ought to be trying to decide behind closed doors. And so embarrassed them that they had to call a meeting. And when they called a meeting, there were 60-some countries spoke, of which I think 2 supported the resolution. All the rest were opposed. In any event, the U.S. modified the resolution so that it would have to be renewed annually. Our general view of this and of Article 98 was that the language has been stretched out of all recognition. Article 16, in our view, and as I would say the vast majority, we certainly view the states members of the treaty, did not allow for the kind of interpretation the Security Council gave. It was the Security Council can request the court to defer a prosecution or investigation for a particular time period, not more than 12 months. And the negotiating history of it is clear that this was in order to do something like if one of the problems that arose didn't turn out to be a problem, it was thought to be a problem. In the Bosnian case, was when Louise Arbour indicted. I get that. When Louise Arbour indicted, maybe that's my wife telling me behind the signal. That reminds me of a statement, a speech that Prime Minister Pearson was giving when he was first running for office, and he was in some church basement. He was just getting the hang of being a politician. He made this speech, and he sat down, and was very happy with what he'd done. He turned to his wife and said, wow. And she looked up at him and she said, you missed 3 good opportunities to sit down soon. In any case, Article 16 is intended to cover a specific situation, like, for example, when Louise Arbour indicted Milosevic at a critical moment, so it was thought, in the negotiations. And that might have prejudice at the end of the war, that might have cost a lot of lives. And so the Security Council should be able to request the court not to act in those circumstances. It wasn't intended to provide a blanket exemption. And that was one of the interpretations put in. Similarly, Article 98, so far as we're concerned, was not intended, it was intended to allow for the existence of status of forces agreements. It wasn't supposed to be an instrument by which any country, in this particular case it's the United States, would negotiate, as Mr. Bolton has said, agreements with every single country in the world so that U.S. personnel would never be subject to the treaty. I think there's plenty I've said that's challengeable. There's a lot more that I would have said. And if anybody is really interested, I'd be glad to circulate a copy of the text, because I want to say something a little larger, because it goes to the heart of it. And that is, Robbie Burns said, to see yourself as others see you saves you from many a foolish blunder. And I'm not sure that there's a clear understanding at just how much opposition there is building up to the U.S. internationally. I think it's germane in the context of the International Criminal Court, because what it was the United States trying to give itself peculiarity should not apply to the United States. That created enormous resentment. The tactics used by the United States in the International Criminal Court discussions in the Security Council created enormous resentment. And I would argue led to, and not in a direct line, and not, it may not have been the principal reason, I'm sure it wasn't the principal reason, but it did lead to the difficulties the United States encountered on the Iraq issue 6 or 8 months later. Because there was so much arm twisting going on. The recalling of ambassadors. The Mauritius ambassador was recalled in the International Criminal Court debate because he was too strong an opponent of the idea. During the Iraq debate, we were trying to promote a compromise on Iraq. The U.S. tried to have the Mexican ambassador recalled, the Chilean ambassador recalled, did have the Costa Rican ambassador recalled, asked to have the German ambassador recalled, and made a démarche in Ottawa to complain about my promoting compromise in the Security Council. That kind of tactic, I can tell you, doesn't do you any good whatsoever. And there's an enormous resentment that comes from that. So, looking at sort of stepping back a little bit, the question was asked the other day, is there a common threat perception? And the man who's not here now, his name is Nicholas, was sitting here in the last panel, assumed there was a common threat. You know, against the common danger we face. I can tell you that the rest of the international community, and I'm speaking as a Canadian from Southern Ontario whose favorite football team growing up was the Cleveland Browns, whose favorite baseball team was the Cleveland Indians, and who worked for the most pro-American Canadian prime ministers in his foreign policy. But I'm telling you that this is getting to be dangerous for the United States. There is a head of opposition building up, and I don't think it's in your interest. There is no common threat perception. And so there is a kind of the second thing is if you stand back, further, another thing, that there is a perception in the United States that through good fortune or bad fortune or fate or providence, the United States has a mission in the world that is educated to impart democracy. I can tell you that the rest of the world hasn't granted you that role. And it is causing a lot of difficulty. Americans are wondering why on earth are these people being so damn difficult? It must be just anti-American. And the rest of the world is wondering why it is that they're having to respond to this all the time. A digression on ballistic missile defense, which I think was well taken care of. But when I asked General Myers, who was at the time the head of NORAD, command, in about 1998, I'd say, what his major worry was that kept him awake at night, it certainly wasn't ballistic missiles. It was cruise missiles. And I don't think, I don't buy the argument that, of course, you protect against all things. There's a fair amount of distraction that's happened because of the ballistic missile issue, as we've seen in Condoleezza Rice's testimony. Further thing that I want to say, and I hope you forgive me for saying this, is that U.S. policy looks to the dispassionate outsider like it's trying to provoke the Arabs and Islam. I say that with great worry because of 9/11, and I don't intend to connect the two. But when you look at U.S. Middle East policy, what U.S. papers were saying yesterday, in public, as a matter of fact, that the shift on settlements between the Palestinians and the Israelis was due to electoral considerations in the United States. It was just stated, as a matter of fact, there's an election coming and this is what's going to happen. I have to tell you that that's very dangerous. These are settlements that you used to regard as, I think, illegal. Most of us consider them illegal. And now you've shifted position on something that is crucially important. You have, in attacking Iraq, a lot of the language has been, at the very beginning, after 9/11, the president, I thought, did a very about Islam. This is about fundamentalist extremism, medieval Islamic terrorists. And that's what it is about. But somehow the war on terror has been divided to be war against all kinds of terror, and everybody's terror. It's become an unwinnable war. You can't win a war on terror. Terror is a tactic. You can possibly defeat a terrorist network, and I think that would have been a helpful way to define it, but maybe if it had been defined that way, it would have done it in explicit purpose. But the attack on Iraq, which is seen by so much of the Arab world as an attack on an Arab country, a Muslim country, an oil-rich country, and talk about bases. One moment there was only 13 bases. It's almost as Richard Clark said, and I agree with what he said in his book. It's almost as though Osama bin Laden has got some kind of mind control going on. He's whispering, "Attack Iraq, attack Iraq." Really, Richard Clark book, you don't have to agree with it. But it's just not, it's manifestly not in your interest. And if you look at the results of the Pew poll, and the results of the study by Ed Georgian, who was U.S. ambassador to Israel and Syria, from, I think it's reference from Rhodes University, the amount of support, Georgian's report says, in its first sort of full chapter, the bottom has fallen out of support for the United States in the Arab world. The bottom of support has fallen out of the United States, has fallen out also in Turkey, and in a lot of other Muslim countries. And it didn't used to be that way. And after 9/11, there was enormous solidarity. Looking back, one of the breathtaking things is seeing how the UN General Assembly reacted, how the Security Council passed the most far-reaching counterterrorism decision, which became the law of the land international, and how somehow the UN was then to be cast into the wilderness and darkness, and a very muscular and I dare say unilateral. And whoever said the other day the United States is being multilateral is just this kind of multilateral or that kind of multilateralism. It's really plurilateralism that we're seeing. We are seeing posses and people being deputized as deputy sheriffs, and the value of alliances where people had a good deal of common values is being deprecated as being old think. And I think that you're getting into difficult territory. So this is in the nature of a friendly warning. One last point. You have a national security strategy document, September 2002, which states as a goal that it will maintain American predominance. When you see China rising, behind China not very far is India rising, and other countries rising, the only way of maintaining that predominance is going to be militarily. And if that's the case, if we're going to enter into a world where it's going to be individual, we're going to abandon multilateral cooperation, then prepare yourself for a long and very dangerous future.
We'll have all the questions and discussion after all the speakers.
Thank you. It's a great pleasure to be here, particularly with all of my friends on the panel here. And you truly have the expertise on the International Criminal Court sitting in front of you here, so I'm somewhat humbled speaking in front of them. But I did want to say that I'm extremely happy to be back at Duke, even though this is a hotel, because I have a soft spot for Duke Law School. Thanks to Professor Madeline Morris, I've had the opportunity to teach at Duke Law in the fall of 2001, and then again in your Geneva program in the summer of 2002, and it's just a great law school. Great law students, great faculty, and I always say yes when I get these invitations from Duke, because it's a great place to come to teach and learn and just visit. I knew that when Paul preceded me, he would basically give me my outline for my remarks. And he certainly has proven that in good measure today. But I say that not because I want to stand up and contest what he has said. Quite frankly, I'm going to supplement what he has said today. But I want to start by going back to the focus of this conference, which is the U.S.-Canadian relationship. I think it's very, very important to know from the perspective of the U.S. negotiator on the ICC until January 2001, when I left office with the change of administrations, that we had a very, very close relationship with the Canadian delegation. I made repeated trips to Ottawa. I met the Canadians repeatedly in Washington. I spent a lot of time in their embassy here in Washington, or up in Washington. And certainly in the Rome conference, I spent every day with the Canadian delegation and with members of it, and forged, in fact, a very close working relationship not only with Philippe Kirsch, but also with all of the negotiators for Canada, but one in particular comes to mind, John Holmes, who is now the Canadian ambassador in Jordan. But he and I worked extremely closely to craft Articles 17, 18, and 19 of the statute, which is the complementary regime of the statute. And it was really John Holmes's tremendous skills drafting and the seeking compromise with other delegations that allowed us, frankly, to ultimately arrive at 3 articles that met our satisfaction in the U.S. delegation. And I think I'm forever indebted to John Holmes for his critical role in terms of bringing the complementarity regime to a very reasonable conclusion at Rome. And even thereafter, as we worked complementarity through the rules of procedure and evidence for the next 2 years of negotiations in 1999 and 2000, Holmes and his colleagues were also at the forefront of those endeavors. It's also true that Philippe Kirsch, even though, occasionally, of course, as friends, I would have some disagreements with Philippe in the course of the negotiations as to how to proceed one step at a time. In large measure, I thought he just did a tremendous job. In fact, I recall distinctly when he was suddenly called to the bar, so to speak, to become chairman of the ICC conference just before we left for Rome, because of the illness of the standing chairman from the Netherlands. I checked around in the State Department and I said, look, I don't know Philippe Kirsch. What do you guys know about this fellow? And I remember hearing back from all of the desks in the state who had dealt with Philippe Kirsch over the years, the highest recommendations of respect and of just accepting him as a very worthy chairman for the ICC conference from Canada. And of course now he's president of the ICC, something that Canada should be extremely proud of as presiding judge, so to speak, of 18 judges at the court. So Canada has that slot. So all I'm saying is that if anyone is under some impression that through January 2001 the United States was somehow at sort of nasty loggerheads with Canada over the fate of this treaty, they could not be more mistaken. And that brings me to a few points that I want to make to come up to Paul's points about Article 16 and 98. Because one thing that I tend to try to focus a lot of my time on, reflecting back at the ICC, is to understand the original intent behind the document. Because I think that's a very fertile field for continued examination as opposed to what we sort of think it might mean today. What did we originally intend these provisions to mean as we were negotiating them? And I think that's work that's going to continue for me for a while as we try to make sure that those of us involved in this or getting that down. But I think it's extremely important to recognize that in the final year of the Clinton administration, which was the year 2000, this was an extremely dynamic year. Remember, Rome had occurred in 1998, and a lot of people think that the whole story ended in Rome. Far, far from the truth. The story continued very dynamically after Rome, and they continued at the UN in negotiations of the procedures of evidence and procedure, the rules of procedure and evidence, as well as the elements of crimes, two very, very important documents. We had a choice, the United States government, after Rome. We could either have walked away from the whole process and simply abandon it, or we could have charged ahead. And we decided to charge ahead in the sense of let's remain very constructively engaged. Let's exercise our influence on the supplemental documents. Let's see if we can address our concerns in further negotiations. And there were many, we had years of negotiations ahead of us to actually build the court, to create all of the documents that the treaty requires in order for the court to operate. And we were able to do that and reach consensus with everyone else in June of 2000 on the rules of procedure and evidence and the elements of crimes. And that was a very positive development. But during that year, I also had to go back to one of the fundamental concerns we had back in Rome and see how we could find some methodology that would work for both the United States and everyone else within the treaty regime, without amending it, but within the treaty regime, to address our primary concern, which, as everyone knows, is what would happen if there were politically motivated efforts to investigate and prosecute the considerably extended and large American military presence overseas in terms of so many of the different activities that we undertake overseas with our military. And that's a concern that certainly as a U.S. official you can't walk away from. It comes at you every single day in Washington. And by the way, one of the things I always find so fascinating when I'm in audiences, whether it be here or even overseas, there's always a almost totally focused concern about what is America's exposure to this court, as opposed to what we were so deeply involved with so often in the negotiations, which was, yes, we know of this concern, but what is this court really all about? What are we doing here with this court? It is to address an unacceptable level of atrocities in the modern world after the Cold War that simply can no longer be tolerated, that we have to establish a means of accountability that is efficient, that is readily available, so that those who decide that they want to engage in genocide, in crimes against humanity, and in serious war crimes at levels of magnitude that, frankly, if there were decisions and planning and conspiracies within the U.S. government to commit crimes on this scale, we have a problem in this country if that ever happens. We have a serious constitutional problem. We have a serious political problem in this country if our government ever sits down to plan this scale of criminal activity that fits the threshold requirements for jurisdiction under the ICC statute. Even though you can make technical arguments that crimes that slip under that threshold could theoretically be attended to by the court, I would argue that both in terms largely of law but entirely of politics, that threshold will be sustained. Now, I like to talk a lot about what this course is worth, why it's so important. Any of you who have spent time overseas in atrocity zones know exactly what I'm talking about. And that's why we need the ICC. And that's why the Clinton administration approached these talks to the very last day, January 20th, 2001, with a sense of constructive engagement. And why I think it's so sad that the successor administration created a policy of destructive disengagement towards this court. Very, very different approach to this court. And it concerns me greatly when I hear officials of the current administration somehow try to link their position to the Clinton administration and say, well, we're just holding exactly what the Clinton people did. They couldn't be more mistaken. They could not be more mistaken. Let me just say that one question that arises continually that I have to answer, so I'm just going to answer it now, because it sort of popped up a little bit this morning at lunch, or at lunch actually. And that is, when we signed the ICC treaty on December 31st, 2000, we signed it. That was the last possible day the treaty could ever be signed. It could never be signed after that date. That was the shutdown date for any country to ever be known as a signatory state to the ICC treaty. Thereafter, you would have to accede to the treaty, which is a slightly different legal process, and it doesn't give you quite the clout or identification as having been a signatory that then ratifies the treaty. We had just finished a year, very intense year. We accepted the rules and the elements by consensus. We had worked out 4 or 5, I guess about 5 different proposals in the negotiations, which I would call further safeguard proposals. And they were very reasonable proposals. They weren't suggesting amending the treaty. They were suggesting some other fixes to the supplemental documents. But we got the support of many of our key European allies. We talked it over. I can't remember whether I got explicit support from Canada, but Canada was fully briefed, was not objecting vigorously to any of these proposals. So we had a good platform of support among our treaty negotiating partners to roll out these additional proposals, which would suggest some provisions in the relationship agreement between the UN and the ICC, would suggest some fixes to the rules of procedure and evidence, etc. All things that were perfectly available for incorporation in documents that were on stream. And that package of proposals, while not providing absolute impunity for the United States with respect to this court, we could never get that, otherwise that would be an illogical construct of being a state party to a court for which you have no exposure to whatsoever. That doesn't fit a logical test in treaty negotiations. But we did have a body of safeguards which we would have supplemented with these additional proposals that I would argue would get us about 98, 99% of the way there. And then I think political reality would make up the other 1%. What was so distressing is that when the new administration came in, all of those proposals were abandoned. They were not pursued whatsoever in the negotiating room in 2001, and they were teed up for 2001. And of course, without the United States behind them, without the United States even in the room, other countries, of course, were not going to proceed with those proposals. So we lost that opportunity. And, at the end of 2001, I really concluded that I found it extremely distressing that even if one is opposed to the court, why would you sacrifice these safeguards? Why not negotiate them, achieve them, and then sit back sort of as a quasi-good neighbor to the court and recognize the protection that all these safeguards provide you, even as a non-party to the court. In any event, that all happened, and then we had the de-signing, or the so-called de-signing, on May 6th of 2002. And from that point onwards, the policy of destructive disengagement went forward, particularly with the signing by the President of the American Service Members Protection Act. Now, all of that is behind us. I would just say that a few things, because I know I'm taking up too much time, as usual. With respect to Paul's references to Article 16 and Article 98, it is true that we as negotiators never, ever, ever envisioned Article 16 being applied as it was in Resolution 1422, and then I think a year later it was 1487. And of course it comes up again in June, again this year, it'll come up for renewal. it was just never envisioned that the article would be interpreted that way. Now, I have said that doesn't mean that just because we didn't envision it, you can't interpret a treaty with fresh thinking and with logical approach, as the Vienna Convention on the Law of Treaties permits you to do. But it is true that Article 16 was envisioned as the ability of the Security Council to shut down an emerging investigation or prosecution by the court for purposes of dealing with a threat to international peace and security that needed to be dealt with very directly by the Security Council without the interference of a judicial option for a 12-month period at least. And it was a compromise in the negotiations that we ultimately bought into, of course. But that was the intent, and I think the farthest you can stretch an interpretation of Article 16 is that the Security Council, when confronted with an entire situation out there, an entire atrocity zone, that is suddenly available to the prosecutor for investigation under the terms, preconditions for jurisdiction of the court, that the Security Council could step in with a Chapter 7 resolution and say, with respect to that entire situation where we can't see investigations or prosecutions pop up for a year, we've got to deal with it very directly. Even though the wording says a case, I think you can stretch it to logically that far, i.e. a situation, because the situation is all over the place, the rest of the statute. That's what the Security Council gets engaged in, is situations. But beyond that, I think it's a stretch. And so there is difficulty there. But I do think, Paul, that although the original American proposal on Article 16 was very, very fatally flawed, by the time it was amended, particularly with, as I recall, the French suggestions of amending the text of the resolution, that it's at least a better product having been amended because it talks about the surrender of an individual and it talks about a particular case. And that at least has some value. Now, with respect to Article 98 that Paul raised, I do want to confirm that the original intent behind Article 98, subparagraph 2, and this is the provision that is sort of the kind of an ultimate fail-safe position for a country like the United States. We launched it in 1995 in talks in Madrid, Spain, with Southern European and North African states on the ICC. And we said at the end of the day, in this process, one thing will survive, and it's our status of forces agreement. So let's start right there. And we did. And as the negotiations proceeded through the years, that concept morphed into Article 98 too. So that there's not a specific reference to status of forces agreements, but the original intent was that would be the essential element of it. And that's why we use the term sending state in that provision, meaning sending state of official personnel overseas could cut a bilateral deal to insulate their individuals from surrender to the court. But it was never our intent that it be played out the way the administration has done so, meaning that it would cover any and all Americans, mercenaries, whoever you want out there. They're covered by the terms of the agreements the administration has negotiated. And secondly, it was never our intent that there would be this global, universal approach to negotiating agreements with every single country. That was just never in our mind. We were going to target particular hotspots in the world where we thought this would be particularly important, where we'd either have status of forces agreements that would be confirmed as Article 98 agreements, or we might have to negotiate a few under Article 98. With those perspectives in mind, let me just finish by the way, there's an easy way to resolve this if the administration would simply compromise a little bit. The Europeans have proposed a methodology for the Article 98 agreements, which I think has great merit, and that is simply that you go back to the original intent, official personnel, not any and everyone, mercenaries, everyone else being covered. And secondly, that the governments that enter into these agreements agreed nonetheless to essentially do a complementarity tasking, i.e. if someone comes under ICC investigation and you want to pull your right under Article 98 agreement, you agree that you will do your job of investigating and prosecuting this individual if merited, and not just bring him back for essentially a sanctuary of immunity. I would close with this one comment. There's so much to say, but so little time. One thing that Canada has done so very effectively, well, two things they've done very, very effectively. One, they've used their skills as negotiators to be power players in negotiations of this character. And we can learn a lot in the United States from that, believe me. Secondly, because I found in major negotiating rooms on treaties of this character, frankly, at the end of the day, it doesn't really matter that you've got a huge army out there. You've got to win on the logic of your position in the room. Secondly, Canada has revised its domestic criminal code so that there is a near parallelism between what they can prosecute domestically and what the ICC can prosecute. That's very good, because the irony, and I close with this, the irony is that today I would argue that Canada is better insulated from the scrutiny of the ICC because of what it has now done with its domestic code than is the United States, where we still have gaps. And that means the judges could actually find that the United States is unable to investigate and prosecute some of these crimes if we were to claim that we could do so. And that's a great danger. I think the critics of the court and the proponents of the court in the United States should be able to agree on one thing, which is to revise the criminal and military codes so that there is a parallelism with the ICC crimes. And at least that would be a first step towards a constructive engagement. Thank you.
Quick change of plans, because Paul Heinbecker will need to leave at around 3:30. Let's have about perhaps 10 minutes of questions and discussions now, addressing, I suppose, primarily the first two speakers, although the others are welcome, of course, to express their views as well. And having said that, I will use my prerogative as moderator to pose a question to the first two speakers. And this said, absolutely, in light of and in agreement with the idea that the ICC's purpose is to address and reduce the level of atrocities in the world, and certainly that's a goal that we must agree is a very high priority. But that said, I have a couple of questions about the particulars. One, with regard to immunities, and picking up something on something that Paul Heinbecker particularly mentioned. Isn't it true that the Rome Treaty would still, even though it said otherwise on its face, but that in light of customary international law, the ICC would be obliged to recognize diplomatic and state immunities, if indeed they exist, and would bind states under customary international law? If the ICJ is correct in Eurodia, the state, the case where, the most recent case where such immunities were tested by the court and upheld, if the ICJ is correct that states are obliged and still obliged to recognize immunities, even for the most serious international crimes, then how can it be that those states, which each are obliged to recognize those immunities, can somehow come together and, through the mechanism of a treaty, gain the right to abrogate those same immunities which each of them are obliged to recognize? And so if that's true, and the ICC is obliged, as I will maintain it, to recognize immunities, then that would, I suggest, limit very much its intended, its success in its intended goal. Quickly, as to Article 16, which it was suggested was a case of, well, that the recent and repeated Security Council actions supposedly or purportedly under Article 16, that was an arrogation of ICC power to the Security Council. Couldn't it be viewed as the reverse, that each of the states that are parties to the ICC and that were parties to drafting the ICC and so on, have under the UN Charter, the supreme international document, have obliged themselves to follow the Security Council's lead under Chapter 7 in maintaining international peace and security. And then for that reason, the ICC treaty is itself ultra vires in purporting to limit the Security Council's Chapter 7 powers to 12-month periods as imposed under a lesser treaty. So those would be my questions.
Okay, we've agreed I'll go first. Two questions. First, on the first point that Madeline has raised. And I know she knows all of this that I'm going to say, but I'm going to say it anyway. And that is that obviously those who are state parties to the ICC treaty have already agreed with respect to the issue of official capacity of their officials not being precluded from the scrutiny of the court. So you can go to the highest officials of any state party and investigate them. I think the issue arises with respect to the officials of non-party states and whether immunities might attach to those officials. And this is how I view it. First, let me just say, original intent. We never ironed all of this out in the negotiations, I can assure you of that. And no one sat there and went through the step-by-step process that Madeline was suggesting to say, which boxes are we going to check off here for exposure to the court and which not under principles of immunity. And
I never thought you did that.
No, we didn't do that in the negotiations. But we did get close in some respects in that I strongly believe that where we came out in the negotiations is that with respect to officials of non-state parties, it is possible that the court does nonetheless would not recognize substantive immunity for heads of state and others of non-state parties, assuming the preconditions to jurisdiction under Article 12 are met, but that the court under Article 98.1, which is another article of the treaty, would recognize the procedural immunity of those officials in light of bilateral or multilateral treaties that would establish their immunity. That leaves outstanding principles of head of state immunity, which might not be explicitly articulated in treaty documents, but are extremely well known in customary international law. And I will just say that the ICC treaty does not provide a definitive answer to that question under Article 98.1 or under, I think it's Article 25 or whatever the official capacity article is. So there is sort of Madeline is right to point out a rather ambiguous problem here with respect to the treaty. It is interesting that in the obiter dicta of the International Court of Justice decision in Belgium v. Congo that she referred to, they were dealing specifically with a national court's effort to override head of state immunity, and they specifically said, our opinion is not intended to rule with respect to an international court going after head of state immunity. So we still have that sort of open, and it may be that we'll get a decision out of the Sierra Leone court soon on Charles Taylor that will help us in that respect, although I think we'll probably have to wait even longer because I think the decision that will come down will be a procedural one soon on this issue and not a substantive one. But nonetheless, it is an open issue. It's out there. It is not resolved. It's open for, I think, fertile discussion. But any analysis that I would give would try to define substantive immunity, meaning that you just have immunity per se from the commission of these crimes. If, for example, you're a head of state, you can go ahead and commit genocide, and that's it. You're head of state. You're immune forever. From procedural immunity, which means after you've left office, are you then subject to scrutiny for commission of crimes of this character? And I just don't think there are definitive answers, but it's an excellent problem. Secondly, on Article 16, before Paul jumps in, well, actually, I've forgotten the question now, so Paul, you jump in and answer it. What was the article? That's my question. What was the article?
Security Council has the right to... Yeah, isn't the ICC provision limiting the Security Council to 12 months?
Yeah. I would not disagree with you. I would say that Article 16, well, the defect that one might find in Resolution 1422 is, yes, it pretends to invoke Article 16 as the basis for Security Council action. It is certainly possible. There's nothing preventing the judges of the ICC, for example, from determining that this is not a proper application of Article 16. That's one thing the judges could always decide. But on the other hand, the Security Council, I agree, it can draft any resolution it wants to under Chapter 7, and whether it is of relevance to the ICC statute or not, there's a very good argument out there that states would nonetheless have to comply with a Chapter 7 edict from the Security Council that may have some relevance to the court, but will nonetheless guide the conduct of states because it is Chapter 7. So that's how I would answer that question.
I prefer to let David answer because he's an actual lawyer. I'm a diplomat, and I don't have instructions from the president. But what I would say on that is that our view is, with particular respect to the way Article 16 has been handled in this case, is that it's ultra virus. The Security Council does not have authority to pass binding decisions on issues in which there's no threat to international peace and security. So fundamentally, it was acting outside its mandate, and the states parties would be entitled to take the view that it's not a binding decision by the Security Council. Whether that still exists as a principle of the law, historically, in this particular case, themselves.
And it would be interesting, if you presented that question to the International Court of Justice, it would be an interesting ultra-virus case for the ICJ to take up.
I just wanted to take Professor Heinbecker's comments about America isolating itself. In that case, what policies should the United States adopt? I mean, it seems to me that what you seem to be saying is the United States, and it's the old allegation, electoral pressure explains the support of Israel. Even if that were true, should the American administration go against popular view in the United States in order to adopt a policy acceptable to countries abroad? I mean, we say, the United States says you have to be sensitive to the domestic situation in other countries, yet when it comes to the United States, we seem to dismiss any American sensitivity to its public opinion as simply narrow-minded parochialism.
I don't think I said that at all. What I did say, if the United States, and I realize that no one likes to be preachy, and I try to limit the preaching. When you take polls around the world, we find out the amount of support that does not exist, and the amount of animosity that does exist. You've got to ask yourself whether you're doing the right thing, whether you're right and everybody else is wrong. Those polls exist in democracies as well as in places that aren't democracies. Insofar as that particular question you raised, the United States used to believe that those settlements were at least obstacles to peace. The international community has taken the view that those settlements are actually illegal. If the United States takes the view that these are now facts on the ground, the Arabs will be entitled to ask, how did they become facts on the ground? How was that allowed to happen? Why wasn't something done about it all this time? And now it's becoming a fact on the ground. public opinion in the Arab and the Muslim countries. But it's not only the Arab and the Muslim countries. I'll give you my perspective. An effective UN is a Canadian national interest. Effective international law is a Canadian national interest. And when an attempt is made to undermine both of those, that's contrary to our interests. When I see the Secretary of State of the United States go before the UN Security Council and lay out a bill of accusation, none of which have been corroborated subsequently, what am I to think about that? What do you think the world thinks about that? Never mind all of the other chatter we heard, and from all of the other dissing of the UN for months and months and months that preceded the war in Iraq. And what are we to think about the aftermath? And what is the world supposed to think about the aftermath? And keeping to this day, Washington hasn't decided what role UN ought to play. By the way, UN isn't seeking a role for itself. It's a little bit like asking the Foreign Affairs Department in Ottawa to run Canada. That's the same size of institution. All I'm saying is, and I say it with greatest respect, and I recognize that I can be misunderstood. U.S. policy post 9/11 has done an enormous hole for itself. And the first thing to do when you're in a hole is to stop digging. And I would say in Iraq, people still got troubles there.
Did you want to comment? Okay. Well, then we will go on with Orentlicher as our next speaker. Thank you.
I'm actually going to speak from here because in a way much more literal than what David said, Ambassador Heinbecker's and David Scheffer's remarks really have outlined my own and covered the point so exhaustively and quite astutely. I think that I am left really as a commentator saying, largely, me too. First of all, I want to say that I was delighted to be invited to participate on this panel because with anyone who's been involved, even in a relatively small way, in the ICC process, I have become a great admirer of Canada and its absolutely singular leadership in shaping the ICC. I'm quite relevant to the issues that you've been exploring at this conference. I also have particularly admired Canada's role in framing the public debate among other countries who support the ICC in response to the United States opposition. And what I mean by that is that I've seen a number of paradigms emerge in responding to the United States position. One of them, I think, is not as helpful as others, and the one that I think is not especially helpful is one that emphasizes the importance of the United States being facing the prospect of prosecution before the ICC as though that's a viable prospect. A number of NGOs in particular have said it's important for the United States to be, in effect, brought to heel before the court, just as any other country. I strongly support the views that Ambassador Heinbecker just articulated, that it's important as a matter of principle for the court in its own legitimacy not to have double standards. But that's a different message than the one that's often been articulated, which is that United States forces have to be brought under control and need to be disciplined before the ICC. In contrast to that paradigm, which happily is not the dominant one, the Canadian government has consistently articulated the message that the ICC, as Ambassador Scheffer also reminded us, wasn't created to persecute American soldiers, it was created to prosecute monsters. And has gone on to say many times that any democratic government that respects the rule of law has nothing to fear from this court. I think that's been an enormously constructive message, and I look forward to continuing to see leadership from Canada in framing the international debate about U.S. concerns. Let me me add just a few comments to some of the remarks that have already been made. First, we're all focusing on this panel, or at least so far, on Article 98 agreements and the resolutions that the United States has insisted upon from the Security Council. As previous speakers have noted, the U.S. positions have been a distortion of the intended application of both Article 98 and Article 16. I think the reasons for that have been well explained by previous speakers. I do think it's striking that the United States has nonetheless sought legal justification for its position on the coattails of the Rome Statute itself, and in a somewhat ironic way, I think that's a bit reassuring. That is, the United States has not entirely disregarded the Rome Statute, but instead has sought to justify its positions within the framework of Rome. Again, obviously with distorted interpretations that, as the European Parliament, I think, put it, is a misuse of the Rome Statute. What is the effect of that in advancing U.S. interests? It's really the question that interests me. First, sticking to the effect of making legal arguments that are difficult for a lawyer to take seriously on their face, I think that has been counterproductive in advancing the U.S. position in the sort of obvious sense that it leaves a taste of illegitimacy. And I think we're being reminded over and over again these days that the failure of the U.S. government in the past year to pay attention to the importance of legitimacy in the eyes of the rest of the world has a cost for the U.S. in advancing its national security interests and eliciting cooperation from allies in pursuing its agenda. Obviously, a more important factor has been that in advancing the U.S. position on Article 98 agreements and the Security Council resolutions that were mentioned earlier, the U.S. government has browbeat other countries. It hasn't secured Article 98 agreements or the two resolutions that the Security Council has elicited through the persuasive power of its logic, but rather through very strong arm twisting in the case of the Security Council resolutions. By threatening to, in the words of the New York Times, shut down peacekeeping missions from Kosovo to East Timor. It was a terrible dilemma for the Security Council to face. I think that Ambassador Heinbecker is quite right that the resolution that was adopted is clearly a distortion of the Chapter 7 authority of the Security Council, let alone of Article 16 of the Rome Statute. Those tactics, the browbeating, the threats, the hostage-taking diplomatically, have seeped across a broad spectrum of U.S. foreign policy diplomatic efforts, and as Ambassador Heinbecker indicated, tainted the deliberations a year ago over Iraqi policy in the Security Council, and had a corrosive effect across quite a broad spectrum of U.S. diplomatic initiatives. The question then, that as an American strikes me as important, is was it worth it for the United States? In the short term, as administration officials point out to me frequently, they've gotten what they wanted. They've gotten many countries to sign the Article 98 agreements, although others have pushed back. They got the Security Council resolutions 2 years in a row, and presumably will get it again the next time that comes up. I have to weigh that myself against two considerations. First of all, whether the risk to U.S. forces of politically motivated prosecutions was a serious one, and secondly, what the costs have been of pursuing those policies. I think I've already made clear what I think the costs are. They have been quite substantial. And they've been substantial not just in terms that matter to me, but in terms of the goals of this administration itself, or of any administration I can imagine holding office in this country. It is remarkable to me that the administration has been willing to incur those costs to protect U.S. forces against prosecutions that are so hypothetical and would involve such a distortion of the Rome Statute that many countries, many strong allies of the United States have wondered what is going on in terms of the United States' appreciation of the actual threat it faces in the situation, the risks that it faces. Let me make very clear that I think it was absolutely perfectly legitimate for the United States to worry about these issues. I think it had to worry about these issues. And I think Ambassador Scheffer showed great leadership on behalf of the U.S. government in making sure that the Rome Statute was framed in a way that would minimize the risk of politically motivated prosecutions. I think Ambassador Heinbecker was absolutely correct at one point when he referred to U.S. opposition today as being fundamentally ideological, because logically the position that we've been talking about this afternoon simply doesn't make sense as a means of advancing U.S. interests, whether those interests are defined in terms of protecting Americans against unwarranted prosecutions or any prosecutions that are imaginable before the ICC, or maintaining allies in the war against terrorism. It has become, I think, quite clear that that people who are defining current U.S. policy toward the ICC, I'm going to be blunt, don't want the court to be successful. And it's taken me a while to realize that. And I'm not describing everybody in the U.S. government by any means, but a significant element of U.S. policy has been defined by people who aren't interested in being shown that the prosecutor is not going to be abusing his authority after all. Now, where does that leave us? Ironically, where it leaves us in terms of the ICC for now, unless there's a change in U.S. policy, it leaves us in a position of being less welcome than we should be or could have been as a friendly neighbor, or even a neighbor who approaches one of benign neglect. For quite a long time, I think there was a hope on the part of many Americans that U.S. position would not be one of actively supporting the court. There was not a realistic prospect of the U.S. being a party to the Rome Statute for a long time, but being either a supportive neighbor or a neighbor that didn't interfere with the court. The supportive neighbor model is one I think that David favored for the U.S. for the period before it was realistically plausible that we would become a party to the court. There are many ways the United States would be extremely helpful to the court in terms of evidence gathering and so forth, and shaping the court in a way it has in the past. What is, I think, what has changed in the past year or so is that type of support, were it possible, wouldn't be particularly welcome at the ICC. And this doesn't stem just from U.S. hostility toward the court, but also the broader issues that the United States confronts as a result of its policies in Iraq in the last year. At this point, I think a U.S. embrace, not that it's forthcoming, but if it were offered, would be seen as something akin to a kiss of death. And so the U.S. government right now is not in a position to be particularly helpful to the ICC. Needless to say, I hope that will change. Let me just close by saying that I assume there's been a fair amount of discussion here. I unfortunately wasn't able to join you until this afternoon, but I assume there's been a fair amount of discussion in the last day and a half about the different approaches to foreign policy embraced by the U.S. and Canada, respectively. And I find Joseph Nye's concept of soft and hard power particularly helpful, not only in defining the general approaches of the two countries, but particularly with respect to the ICC. I think that U.S. policy in the past several years toward the ICC should provide rather strong validation for nice central thesis, which is that we're more likely to attain enduring support for our policies if we elicit support through the persuasive power of our logic, and by attracting people to want the same goals we want, than through the brute force of hard power tactics. Hard power tactics have been exemplified by the Article 98 agreement policy and by the Security Council policy, in contrast to the Clinton administration, although it used a mix of hard and soft power in its approach toward the ICC, emphasized persuasion and diplomacy, as David reminded us, and with significant effect. And I think that when we look back at the long-term impact of U.S. policy on the ICC, we will see quite clearly, in fact, I think it's quite clear already, that the Clinton administration's policy was quite persuasive and quite powerful in shaping the court. And the Bush administration's policy hasn't had that effect, but on the contrary, has produced an enormous amount of resentment, which is costly, and that's the important point. We knew there was going to be resentment. I think what perhaps wasn't fully appreciated is how much blowback there would be in a harmful way. So I'll end there.
Started out with a lot of points, but I'm going to try to cut them down. First of all, my thanks to Scott Sullivan and Mike Byers for inviting us, and I think it's been a very interesting day when I've been here, and I presume yesterday was also very interesting, although I was not here, but today I have been here, and it was extremely interesting. Second, I feel like a lion in the den of Daniels. Mike Sharp and I, and Dave Scheffer and I, and Diane Heinbecker and I have all been on platforms together, and we could each adopt each other's case if we wanted to, and we could have a reverse debate if we like. But instead, I'm going to outline some of the problems I see with the current ICC treaty and indicate some of the solutions that I see to them. I've written all of this up in lots of overview articles that I'm sure most of you have read already, so I'm going to be very brief with them. First of all, if the United States or Canada supports democracy, it has to recognize that democracy may elect or select murderers as their chiefs of state. That's what democracy is all about. That does not mean that they should get away with it, but it means that is it the foreigner's business to finger who are the murderers who have been elected or selected by democracy to be head of state. I want all to remember that a fifth of the world is Chinese. Think about that for a minute. A fifth of the world is Indian. Think about that for a minute. A fifth of the world is fundamentalist, whether Islamic or Christian or Jewish or whatever. 3/5 was a majority last time I counted. That means that we are not in a majority here in favor of the ICC, whatever the rationales might be. The real question then comes down to who decides. Who is to be the judge of the ICC? What is the evidence to be accepted for a guilty verdict? And more important, who pays for all of this? Do we pay? Does the taxpayer pay? If the UN pays for it all, then we pay for whatever our share of the UN budget may be, which means the American taxpayer, which means the Canadian taxpayer, which means whoever is involved in paying the UN dues pays. I presume that a defendant doesn't have to prove his innocence, but a prosecutor does have to prove guilt unless you follow a civil law system, in which case the judge decides guilt and innocence depending on the evidence presented to the judge. And we have seen problems arising over that already. How does a defendant, when it comes down to it, prove his innocence, or how does a prosecutor prove his guilt? Let's take the example of General Schwarzkopf, who is an American general, who bombed a bomb shelter in what he thought in Baghdad was a bomb shelter. How can he possibly introduce evidence that local spies told him that that bomb shelter overlay a communication site? How can he possibly introduce evidence of radio intercepts that indicated that that supposed bomb shelter overlay a communication site? how can he show that under the terms of the Geneva Conventions that the taking out of the communication site was worth the collateral damage? Or how can a prosecutor show that it was not worth the so-called collateral damage of taking out a bomb shelter at the same time? How do we know? Finally, of the objections that I just jotted down here, with regard to the double standard and U.S. exceptionalism, the U.S. indeed does not want to be prosecuted for political purposes, but are we going to prosecute North Korea, the Russians for their actions in Chechnya, the Kosovar Albanians? We are prosecuting some Kosovar Serbs, I understand. Who performs these arrests? At whose expense? Who tries them? How do you try Russians? How do you try Chinese? How do you try Kosovar Serbs? How do you try Kosovar Albanians? Or do you leave some of these people out of your rationale and say that, well, double standards don't apply to them, it only applies to Americans? In which case, are you not applying a double standard? What are some of the solutions? Some of the solutions that I've jotted down, aside from noting that the law is not the sole bottom line of any international affairs, that you also have morality, force, economics, small p politics, meaning who wins the next local election, big P politics, meaning how do you present yourself to the world in general, history. There are at least, I've jotted down 6, 7 different categories. There are at least a half dozen, and then multiply the factors by at least 2 or 3, because you find the experts in each of these areas disagree with all the other experts in each of these areas. And so you've got to double the number of people whose advice you hear. And I would suggest that some of the solutions would be in local procedures. That is, have Rwandans try Rwandans, whatever their local procedures might be. And that way you would eliminate this possibility of us telling them who their real villains are and sending others down, the real murderers, down to live back in the villages where they murdered the women and children whose houses they live next to. What about a world government? That is a possible solution, but is there one? Is there a world legislature now? Is there a world judiciary in existence right now? Do we want one? If we do not want one, we do not want an ICC. If we do want one, that's fine. Let's dig for it then, instead of trying to get there through the back door of an ICC. A third possible solution is simply worldwide exposure. Normally Truth and Reconciliation Commissions, but not necessarily. They might work in some cases, might not work in others. But exposure of what your allies, what your friends have done, what the Russians are doing in Chechnya, what the Chechens have been doing, what the Kosovar Albanians have been doing. Would you not be interested in those things? Should you not be interested? Should the ICC be interested in those things? Would the ICC be interested in those things? Would there be a prosecution of those people who are popular? With whom would they be popular? What does legitimacy mean? Legitimate how? Legitimate legally, legitimate morally, legitimate in the use of force, legitimate economically, legitimate politically? What does it actually mean to have a legitimate operation? Fourth, national remedies, embargoes. The U.S. had its Sullivan rules and stuff with regard to South Africa. We could have similar national remedies with regard to any country that we regard as violating our standards of international justice. Fifth, there would be personal remedies. We or our corporations can refuse to deal with people they don't like. Of course they can. That means economically they may lose, but morally they may win. That's a personal remedy. Sixth, do nothing. The Waldheim remedy. Kurt Waldheim, I might remind you, was twice Secretary General of the United Nations, President of Austria, never convicted of anything. We haven't done anything to him. He can spend his old age skiing around Innsbruck if he likes. But he can't get a visa to go anyplace else because nobody cares. Nobody wants him. That, it seems to me, is a perfectly adequate remedy. In short, it comes down to what we're really concerned about is the future of international law. Does Canada really stand for treaties that are going to be predictably violated by Canada and by other people whom Canada really likes? Or does it stand for treaties that will be observed? I might say that I feel the same way about the treaties that deal with what are they called? Not nuclear weapons. I'm thinking of the landmines treaty. Are they thinking of things that they really want observed? Do they want landmine treaties to be observed except with regard to North Korea? Do they want landmine treaties to be observed except with regard to Canadian activities in Afghanistan? Or do they want to find exceptions to the landmine treaties? In which case, why don't they come publicly and say what the exceptions are, so that the U.S. does not have to stand alone on these matters? In short, I find the U.S. really standing up for international law and the sanctity of treaties, and Canada, in this regard, standing against those things. Let me stop right there.
For lots of reasons, I'll let Ambassador Heinbecker speak first.
Yeah, I really do have to go, and I hate to run out when it looks like it's getting the hard part, but I think I can, on the last point, on landmines, there is no question at all that we believe in implementing treaties that we sign, and we believe in promoting treaties that we think should be implemented. Insofar as landmines are concerned, I'm always struck by the argument that if the United States is not part of it, it's not worthwhile. The United States should be part of it. There's no question in my mind about that. The Canadian military, the German military, sometimes thought to have some prowess, the French military, the British military, all of these allied countries, virtually all of the United States NATO allies, have signed the Landmines Treaty. And the Landmines Treaty has four things: no production, no storage, no use, and no export. And even the United States is more or less observing, except for the use part, and even there, it's improving its sort of posture. Those things are being observed. So we didn't get everybody in. The Russians are not in, and maybe they're not behaving correctly. But there are hundreds and hundreds of thousands and millions of landmines being removed, and they are not being replaced nearly so readily because there's a ban on production and a ban on export that almost everybody is observing. I don't know, maybe you can't, maybe, if the argument is you shouldn't pass a treaty unless you're going to have perfection, then that may be, maybe that's a correct interpretation. But I would settle for saving a lot of people's lives and a lot of people's limbs. And it's not going to be Canadians and it's not going to be Americans who are going to be harmed by that. The same thing I would say on the International Criminal Court. Is it going to be easy to bring a Russian leader to book? Probably not. It may not be impossible. Milosevic eventually came into people's hands. We're hoping that it may have been possible that Saddam Hussein would one day have come into somebody's hands too, short of the maybe not. But the fact that you can't get everybody isn't any reason why you shouldn't be trying to establish that norm and have it accepted and have it internalized in the legislation of countries. And here, in particular case for the International Criminal Court, there may be problems with aspects of it. No one said it was perfect, and it's taken an awful long time to get to where we are, many decades thinking about it. But there can't be any question, I don't think, in anybody's mind, that if you can put the man who's the head of the larger revolutionary army in northern Angola, who runs the world's biggest child soldier army, if you can put him on trial, if you can put the people in Bunia on trial, you've actually done that. If you can put Charles Taylor on trial, if you can put Ferdisenko, if he had died, on trial. Those are good things. They may not be enough, but they're certainly worth having these treatments for. General answer. And I apologize because I'm sure I just opened up another front.
Thank you so much for being with us.
I just wanted to add something on the point about whether it's undemocratic, if I understood you correctly. This is an issue that I take very seriously, and I think you and Madeline have done a great job of framing that issue for us. I'd like to make 2 points in this regard. First, we tend to forget in the American debate that many countries ratified the ICC, and 92 so far, and I can't remember the number of signatories. They do so in large part to enhance, for many of them, to enhance their own democratic system. N.D. Moravchik, a political scientist, now at Princeton, but mostly at Harvard, has done research about which countries ratify treaties like the ICC and sign on to rigorous enforcement, international enforcement machinery, and has found that that the countries that are first to sign on to international enforcement machinery in the area of human rights are fragile democracies that are recovering from a recent history of bloody conflict, who want a backstop for their own very tenuous democracy in case it ever again falls into the abyss of lawless violence. And so, yeah, we need to recognize that many governments actually do exercise their democratic right to become fully bound by the Rome Statute regime. And the vast majority of those countries that have ratified the ICC statute are vibrant democracies. In fact, they've been in the lead in ratifying the Rome Statute. The other point that I think is relevant here is one that I think was alluded to earlier, and that is that the complementarity regime of the Rome Statute has in fact had the impact already of strengthening national domestic capacity to enforce, to prosecute atrocious crimes at home. I recently completed a study for the United Nations best practices of states in combating impunity. And one of the things that I learned in the course of preparing the study was the degree to which the Rome Statute has already led many countries to strengthen their legal capacity. The case of Canada was mentioned, but it's happened in other countries as well, and the process is underway in many others. The very existence of the Rome Statute has led countries to buck up their national legal system, and more important, has provided an incentive for countries to prosecute wrongdoers at home that they might not have had the political strength to do without the International Criminal Court. We've seen this phenomenon already in recent years in the context of universal jurisdictions, where the credible threat of prosecution abroad has created a broader democratic space in countries like Chile and Argentina to prosecute wrongdoers whom they couldn't have politically touched before. So the democracy issues are very serious, but I'd like to recognize the complexity of them as well, and on the whole, the emergence of these transnational and international mechanisms have bolstered democratic governments, not weakened them.
Well, my good friend Rubin has always raised very provocative issues to address, and I guess I would just comment on a few of them, or a couple of them. He raised a very good point, although I wouldn't reach the same conclusion, but he did raise the whole phenomenon of truth and reconciliation commissions and what one essentially might call non-judicial mechanisms for addressing issues of accountability in post-conflict societies. And we've become extremely well versed now and are always gaining more and more experience about these non-judicial mechanisms. There's no immediate pathway in the ICC statute towards embracing the non-judicial mechanisms versus the clear pathway that the statute sets forth for a judicial process of investigation and prosecution. And yet I have some confidence that from simply a point of political that issue will probably begin to evolve in a way that indeed will embrace the non-judicial mechanisms. And the reason why I say that is that the court, in any event, and the prosecutor has made this very clear, is going to have to focus its attention primarily on the leadership cadre of the atrocities, those who have planned it and have had a command responsibility or a very significant individual responsibility with respect to those crimes. And there will be a limited number of suspects in any particular atrocity that the court will have the resources and real capability to go after. And frankly, that's the pattern that has been emerging for years now in international courts, is to focus particularly on leadership cadre. In fact, the International Criminal Tribunal for the former Yugoslavia only last week approved a new rule, to its rules of procedure and evidence, that says they will only now focus on those with the greatest responsibility, using the Sierra Leone language henceforth. And that came after an instruction from the Security Council a week earlier suggesting that they go down that path, and they have now embraced that path. So there is that trend. What does that mean? That means that the prosecutor, I think, is going to increasingly develop a methodology that opens up a lot of space in any particular atrocity zone for truth and reconciliation commissions and other non-judicial mechanisms to take hold and to basically deal with the vast numbers of perpetrators at the mid-level and low level that the ICC simply could never possibly address accountability for. And those people will either be dealt with through unique structures of non-judicial attention developed under the circumstances, or, depending on the strength of the national judicial system in that area, national courts will take on some of that burden, whether immediately or as they further develop in a post-conflict society with support and everything. So it's a real issue, but it's also one we've struggled with in the negotiations, and that's a long story in and of itself. I'll just briefly say that, you know, it's interesting, there were so many governments out there during the negotiations that had their own, if I may put it this way, believe me, America has had its shameful past as well, when you talk about slavery or otherwise. But they had their shameful immediate paths, particularly in Latin America and elsewhere, where the application of amnesties was extremely controversial. So when I even raised this during the negotiations in a very open way, I thought I was doing everyone a favor by getting it out on the table and suggesting, now let's talk about this and think about how we address this in the statute. Because it's a reality out there. So let's talk about it. Let's just talk about it, okay? And after I finished speaking, the number of delegates that rose and walked around for private little conversations with me, saying, you've just placed me in an impossible position with my capital. I can't possibly report back on the cable tonight that I'm sitting here talking about the amnesty provisions that are creating hell back home. So can we get past this? You know, so it is a very good point, though, that I'm glad Al raised.
Questions and comments? Gentleman right in the middle.
Thank you. I'm Marcos Sassoli from the University of Geneva. As I'm perhaps the only one here coming even under criminal law, from a criminal law point of view, from a civil law tradition, I just wanted to correct Rubin. It's not true that in civil law it's not the prosecutor who has to prove that someone is guilty. This is laid down in the European and in the American Convention on Human Rights. The majority of state parties of which are civil law countries, and this is a fundamental human right, and it is indeed the prosecutor who has to prove that someone is guilty and the presumption of innocence. The argument, to come to your argument, that it is difficult to prove violations of humanitarian law, in particular of battlefield crimes, has obviously something true, but what consequence should we draw from that? Should we draw from that the consequence that simply we don't prosecute anyone, because your argument could also be made by Milosevic? What's the difference? How do we know that Milosevic does not have to? Some secret spies and so on. Knowing that you have an even-handed approach, I think I know that you are also against the ICTY, and this is at least consequent, while in the US position has such a double standard, which shocks a lot of people. For instance, in Serbia, saying they are against any international criminal court which could ever be competent for them, but for us, they were the main supporters of such a court. And finally, I think your argument ends up in the argument of the defense in Nuremberg, to say simply, if there is system criminality, if it is a criminality which represents the state, then it is something for the interstate level, and we should not look after the individuals. And so I wonder, do you also consider that Nuremberg should not have happened? Then, two more points. The preference to local procedures, I fully agree, but I think this is exactly what the ICC statute also has. And ideally, the ICC statute would work as nuclear deterrence. It would never work. But simply local procedures work better, because domestically prosecutors, governments can say, if we don't prosecute, it will be the ICC. And finally, about taking international law seriously, there I must very frankly say that, be it on the level of accepting new international obligations or complying with existing obligations, it doesn't seem to me that the US has a good record. It has been, again, condemned by the International Court of Justice on a clear obligation under the Vienna Convention on Consular Relations, and on so many declarations, in particular by the present administration, really saying clearly, we don't care about international law, we don't need permission by anyone, which means we don't care about law and institutions. And I think this is also something which provokes so many others, while I think just a very powerful state, which has a moment in history where it is the most powerful of all, would have logically an interest rather to get rules and to play with the rules, because the moment will come when it is no longer the most powerful, and that could be an occasion that finally a powerful state tries to further an international order from which it could benefit too. Thank you.
Thank you. As that seems like a very appropriate last comment or question, but one that surely we have to allow a response to.
Thank you for allowing a response to it. First of all, with regard to Nuremberg, it's interesting that at Nuremberg it was agreed beforehand not to mention the secret article of the Hitler-Stalin Pact. The Nuremberg Tribunal did try only the convicted Nazis, but not the Russians, for doing exactly the same thing that the Nazis had done. This in no way excuses the Nazis, in no way excuses the Russians, but one has to take Nuremberg with several grains of salt. Secondly, with regard to the ICTY, you may disagree, Mark, this is fair enough. With regard to the ICTY, one mustn't forget that the fellow who handed Milosevic over to the ICTY was then shot and killed by probably by Milosevic's supporters. We did not resolve the problem of a right-wing Serb movement and a left-wing Serb movement and the middle-of-the-road general population in former Yugoslavia, in particular in the Serb parts of former Yugoslavia. And Milosevic has not yet been convicted, and I'm not sure he will be convicted. It's really very difficult to say. Same thing is true in Rwanda, where I have been in touch with one of the defense counsel who claimed, perhaps wrongly, perhaps rightly, that some of the terms, some of the actions of the tribunal have been less than defensible. Let me just leave it at that and get on. I do agree that the ICC does allow for local procedures. I have yet to see what the Spanish reaction would be if Chile attempted to try some of Franco's friends, as Spain attempted to try Pinochet, or at least get extradition and then try him. I'm not at all sure that the rule of law is even-handed in these regards. This in no way disputes the point properly made by Diane Orentlicher that the existence of the statute does encourage other national tribunals to exercise their authority and encourages national legislatures to exercise their national authority to criminalize various acts and not to give immunity to former high officials of the state. But query whether this is worth the cost in the ICC, which I've been into already. I'm not going to go into again. Finally, Marco, I agree with you that the U.S. record is not good at the moment, nor is it good in the recent past, but nor is anybody else's record. I think that international law has reached a stage of, I won't quite call it a crisis, but it's similar to a crisis stage. There's an awful lot of folks who have never read any Roman law, just keep citing. We don't realize the Roman Empire rested upon the Roman sanctity of treaties, and the Romans violated their treaties from time to time. As anybody can find if he wants to read, only read Livy or and other things. And these are in English translation, published in the main by Penguin, and in the main they're easily available for people who care to read them. Most people do not care to read them, but instead make grand assertions about the American violations of international law. No, America has violated international law, so has every other major power. The first two books I did were on the British expansion into Southeast Asia, and particularly Malaysia, and documented page after page of British lying bluntly to their Malayan folks and to the rest of the world about what they were doing and the logic behind what they were doing. This is not new in the United States. It is to be expected. Same thing is true in Europe. Same thing is true in Canada. We're all basically human beings under the surface, and therefore we're all basically the same. Thank you.
Thank you, and I'd like to thank the panelists and the participants for a very interesting and stimulating time.
Thank you very much, Madeline, and to your panel. And as has been the case with all the panels, I guess we will agree to disagree on some of these issues because they are valid points depending upon your point of view. Ladies and gentlemen, this concludes our conference. We want to thank you very much, not only for being here, but for your participation. We hope that, again, you will give us the benefit of your feedback through the evaluation form so that we can continue to make these conferences as good as we possibly can and a benefit to you. With that, we wish you safe travel back wherever you're going, either locally or at a distance. We look forward to having you back at Duke and Durham again. Thank you.